Jonathan Pollard. I'm going to tell you about my 100 case strategy or theory. And I'm just going to jump right into it. So, if you don't know who I am, if you don't follow my work, I represent employees in employment law cases against corporate America. I've done this for the past 10, 11, 12 years now. For about 10 years, I focused primarily on defending non-compete and trade secret cases that companies would pursue against departing employees. And we litigated more than 200 of these cases, and we had a great track record in terms of our results. Of course, we lost some cases. You always lose some cases when you litigate that volume of cases, but by and large, we got what I considered outstanding results in a landscape that was unfavorable, to say the least. And by that I mean Florida has a long-standing, long-running non-compete abuse problem, coupled with several other problems in that direction that have basically made it ground zero for non-compete abuse. Now, I did that for 10 years, and throughout that process, I came to the realization that I could never really make a big enough dent in corporate America just by defending non-compete and trade secret cases. Even if I was pursuing whatever counterclaims were available that I thought were plausible, I could just never get enough leverage. I could never make enough of an impact. I could never really stick it to corporate America the way that I would need to do to have the type of impact that I believe is possible. So I decided about a year ago that I was going to wind down our firm's work in defending non-compete and trade secret cases and go in a different direction. Now, a word about that. We still take some non-compete and trade secret defense cases, but we no longer have 30 or 40 or 50 of them at a time, and that's no longer our focus. And some people say, oh my goodness, how could you do that? How dare you? Well, number one, it's not my job to play nursemaid to the world, and I don't just exist for whatever people want to cheer for. I have my own thing that I'm working on here. I have my own bigger picture that I'm working on. Number two, we still take some of those cases, and we'll take particularly egregious cases. But number three, we actually, over 10 years, established a new body of case law and basically created a blueprint that other firms can now follow to defend employees in non-compete and trade secret cases in Florida. And I see it to this day. There was a recent case involving a Florida company called Blue Grace Logistics. Blue Grace Logistics is a billion-dollar or near billion-dollar company that likes to sue people over non-compete agreements. And boy, they just got their hat handed to them in the United States District Court for the Middle District of Florida. And if you look at that order from the Middle District, it cites a couple of the cases that our firm litigated. And if you look at the briefing, it's obvious that, this is our playbook. This is how you do it. And I think that's fantastic. I'm happy to see that. Some people say, oh, doesn't that cost you business? No, I don't need that bit. That's great, right? The more lawyers out there who are representing employees and fighting the good fight and capable of fighting the good fight and successfully fighting the good fight, the happier that makes me, okay? Because it's about all of us. It's about everybody in this together. All right, I cheer everybody on who's on the side of what is right and what is just and what is fair. So I decided I was going to pivot from defending non-compete and trade secret cases in a pro non-compete state like Florida. Florida is ground zero for non-compete abuse in America. Florida has the most regressive non-compete legal regime. It is absolutely backwards. Some of the case decisions, especially out of the Florida state trial courts and the Florida federal trial courts, some of these decisions are absolutely mind-blowing and frequently reversed by appellate courts. I mean, I've gotten a number of these decisions reversed at both the state and federal level. Yes, that means even in the United States Court of Appeals for the 11th Circuit, right? So I do have a little bit of knowledge regarding this particular subject. The point being, I was no longer going to fight with one hand tied behind my back. I was just gonna flip and go on offense and just go on the attack constantly, file lawsuits, and just get them to trial as quickly as possible. So I've started pursuing plaintiff-side employment cases, and particularly discrimination. So let's just unpack that. Race discrimination, sex discrimination, age discrimination, sexual harassment. It's kind of the discrimination bucket. People are just ridiculous these days. And so, on all sides, okay? You have people who say, my company has a pride flag in the cafeteria, and as a Christian, I feel I'm being discriminated against, okay? Trash. Just shut the front door. Go home. Nonsense. On the flip side, okay, you have somebody who says, I'm being discriminated against, and it must be because of my race. And it's like, well, let's look at your performance metrics. Well, yeah, I mean, I had a number of write-ups and was on performance improvement and this and that, and I was always late, but I really feel like I'm being singled out, on account of my, no, again, trash, right? I'm talking about real, actual discrimination. This is the problem with American society today, okay? People can't hold two seemingly conflicting ideas in their head at the same time. Is everything discrimination? No. Are some things discrimination? Yes, right? So over the past couple weeks, we've started filing these cases, and we filed some really egregious ones. Racial discrimination. We just filed a race discrimination case where the employee went to HR twice to report blatant racism, being called the N-word, being called a mule with N-word teeth, being called a dumb N-word. And the second time he went back to HR, the company told him, we're just going to terminate you. We don't need your help anymore. Thanks for playing. Right? Wow. What is that? 1981. That's a 1981 claim. 42 USC 1981. Title VII? No. Damage caps? No, thank you. 42 USC 1981. Original civil rights law. No damage caps. Yes, punitive damages. Unlimited possibility. That's what we're talking about, right? That's race discrimination. Age discrimination. We'll take those, right? America has an epidemic of age discrimination. A lot of folks, they get to be 60, 65, 70. I've met plenty of people who are 65, 70, still going strong in their career, but the powers that be come to them and say, hey, you're 65, it's time for you to retire. And we're not talking about a job that would physically lend itself to having a hard cap retirement age. We're talking about a job that the person is capable of doing and doing well, but a company just says, we want some young, fresh blood in here. You're old, you're tired, you're used up. Bring in some 35-year-old hotshot young gun, to take your job. Again, blatant age discrimination. That's what we're talking about. Sexual harassment, sexual assault cases, workplace defamation. So I see that one all the time where a person, an employee, is leaving a company and the prior company goes on a smear campaign and just lies its face off and destroys the person's reputation or attempts to do so, right? Frequently see lies about stealing information, stealing data, stealing money, just the list goes on, committing crimes, felonies, etc. Workplace defamation, we do those. The bottom line there is we get hundreds and hundreds of leads and inquiries and potential matters every week, and we screen through them, and my colleagues whittle them down to ones that meet certain parameters, and then yes, personally me, I evaluate the 5 to 10% that get past all of the other screening mechanisms, and I decide whether or not we pursue those. And so what's happening in this particular space, in this particular area of law, is that there has been a decades-long market failure with respect to plaintiff-side employment cases. And I will break that out for you. So take an egregious case, like we just filed the case on behalf of that construction worker. It was called those terrible racial slurs, reported it to HR, and was fired in retaliation. In my view, that's blatantly unlawful. I think the case is an absolute banger, and I just want to take it to trial. We have dozens of cases that are of that caliber. And in some of those cases, yes, the company and their insurance carrier have gotten wise and come to the table and negotiated, reached a settlement. But in the majority of those cases, the company and its insurance carriers, in their infinite wisdom, or at the wisdom of a big law firm that likes to litigate these cases because they can bill hours on it, they have decided that they want to lowball in settlement negotiations, in pre-suit settlement negotiations. So how do we get there, right? How did this particular arena of law get there? And I'll explain that. There are two driving forces here, okay? The first force that's pushing this is, and I'm just going to be blunt and just call it how it is, big firms have an incentive to litigate these cases because they're billing hourly. Unless the firm has some alternative fee structure or arrangement with the client, the insurance carrier, etc., they are billing by the hour. So if the case goes off, if the case goes to litigation and is in litigation for a year and a half, 2 years, 2.5, 3 years, that is going to make the firm a lot of money. So there is obviously an incentive there, and that incentive gets implicated in pre-suit negotiations. I've even had certain other lawyers, mediators, professionals, etc., tell me their impression that certain corporate lawyers, they want you to make a demand that they can convince their client is unreasonable. They want you to demand something unreasonable so they can go litigate and bill their hours. The most dangerous thing you can do is actually be reasonable with them, because then they'll have a hard time convincing their client not to at least engage and negotiate. So you've got that incentive on one hand, okay? But it's not just corporate America and corporate lawyers who are driving that train and who have created that market failure. It's plaintiff-side employment lawyers. Not all of them, but many of them. Because many plaintiff-side employment lawyers just want to make a quick buck. That's it. And look, again, I will be so straight with you. There are some people, there are some plaintiffs, there are some clients. In fact, there are a lot of people, plaintiffs and clients, who think their case is worth $1 million and it's just not worth $1 million. I get so many leads, inquiries, calls, emails, etc. And I'm not the front line screening on these, but I still see some of these and hear about some of these. And the sheer number of people who think they have the biggest case in the world is just mind-blowing. All these people are not lawyers who don't know how to actually evaluate, value, and assess a case or the reasonable settlement value of a case, just have this feeling that their case is worth, and it often tends to be specific, right? That their case is worth at least $1 million, or at least $1.5 million, or at least 600,000. And these are just numbers that the person they've got some attachment to the number. They think that number is good enough. But what they think the number is, or what they need to get out of it, has no bearing on what it is actually worth as a matter of proper analysis and valuation. That said, there are many plaintiff-side employment lawyers who are underselling these cases. They're going pre-suit through the EEOC, God bless them, the EEOC, doing a pre-suit EEOC mediation where corporate America and their insurance carriers look at pre-suit EEOC mediation and think, wow, hope we can buy this case out for 20 or 25 grand. That's how they look at EEOC pre-suit mediation. They're not looking at that and thinking, okay, what's the case really worth? What's the risk? What's the exposure? How much should we actually pay to buy out the risk right now? They're not doing that. They're trying to lowball it. And there are a lot of plaintiff-side employment lawyers who go along with that. They want the lowball. They'll accept the lowball. They're begging for the lowball because they've got 10 of these cases, right? And there's nothing wrong with volume. I mean, I've got a huge volume of these coming in right now. There's nothing wrong with volume, provided you are properly handling the cases, provided you are not discounting the case value and you're giving your clients a fair shot and you're doing your job and advocating to try and help them get something that you think is reasonable. And there are a lot of plaintiff-side employment lawyers who are not doing that. They're going for the low ball. There's a case, say a case is worth objectively, and yes, there can be and there are cases that are worth objectively X amount of money. And corporate America's newest hang-up, corporate America, insurance carriers, defense counsel, their newest nonsense is the idea that the only real damages are economic damages. Nothing else matters. Your reputation, emotional distress, loss of dignity, humiliation, anything, anxiety, depression, none of it matters. It's not economic damage, it's not real damages. I cannot count the number of times that the big three, corporate America, insurance carriers, and defense counsel, have said to me, well, your client has no damages, right? Take Jerry. You can just look on my LinkedIn. You'll see the case. I posted it. Jerry Jennings versus J.W. Cheatham LLC. Take Jerry, right? Being repeatedly called the N-word at work and then getting fired when you report it to HR. Is the corporate, and this is not, J.W. Cheatham has not responded to this case yet. We'll see what their response is. But I've had many other cases with a similar fact pattern, something that egregious, and the company takes the position of, well, your client was only making $15 an hour. So, what do you want, right? You want 10 grand, you want 20 grand? Client wasn't making any money. He has no damages, right? Lost his job, okay, I'll get another job. He's poor, you know? He doesn't have any damages. There's no economic damages here. What's the case worth? Well, that's not how the law works, okay? That's not how the law works. The law recognizes categories of damages for emotional distress, loss of dignity, etc. That's compensatory damages in employment law speak. But under something like 42 U.S.C. 1981, which is the original Civil Rights Act, not this watered down Title VII, but the original Civil Rights Act, there are no caps on compensatory damages and no caps on punitive damages. So when something like this happens and it's egregious, especially if it's egregious race discrimination, the value of that case cannot simply be fixed to economics. It cannot simply be fixed to what the person made hourly. It goes far beyond that. There's compensatory damages, there's punitive damages, there's attorney's fees. So when you factor all this in together, you have a case where realistically, the case is going to go off at trial for millions of dollars. I know there's no guarantees in law or life or litigation. Juries can do whatever, but you look at a case this ugly, yeah, it's people know it when they see it. They're going to see this case and they're going to go nuclear. And it's going to be a big number, okay? But even if we just get ultra conservative and we say, okay, that case, right, egregious race discrimination, you know, modest wage construction guy, black, being called the N-word, gets fired. You ask yourself, what's that going to go for at trial? Must be super conservative, right? Let's say he gets $20,000 or $30,000 worth of lost wages. What's a jury going to put on that for compensatory damages? Loss of dignity, humiliation, what he had to go through, right? Because that is important. Now, to back up a step, I'm not one of those people who says your feelings are rights. Your feelings are not rights. They're different things. And all these entitled brats who get in their feelings over everything, I'm sorry, I'm not on that, okay? But this is different. There's a certain level that we can all agree when something hits this level, it's unacceptable, and it has a psychological, emotional, mental impact on a person that should be compensated. And that's what we're talking about here with this particular case and many other cases of this nature. So what's the case go for? Conservatively, let's just say it goes conservatively, right? It's going to go, in my opinion, for millions of dollars. But let's be ultra conservative and say it goes for $500,000, okay? $500,000, ultra conservative. When I got out attorney's fees, let's be ultra conservative about the attorney's fees. Let's say by the time it goes to trial and then there's motions after trial, let's say when it's all said and done, there are $250,000 worth of attorney's fees. Again, very conservative when it comes to attorney's fees. But $250,000 on our side to represent the plaintiff and $250,000 on the defense side to defend the company. That's 500, 250, 250, that's $1 million. The case is worth $1 million, conservatively, ultra conservatively, rock bottom. It will cost them at least $1 million if they go to trial and roll the dice. What's a company, and again, it didn't happen here because I sent them a demand letter and they just ignored it, okay? That's called fool around and find out. We're gonna find out, right? We did the fool around phase, and now we're going to find out, okay? And I can't wait because I'm gonna be proven correct, right? I've literally doing this flip to what I'm doing now, right? The plaintiff-side employment cases. I'm all in on this. I've invested everything on this. This is what I'm gonna do, right? It's either gonna go off like gangbusters and I'm gonna win spectacularly, or it's gonna fail miserably. But I'm betting on myself here. I know what I'm doing. I've been around long enough to be equally sage and savage at the same time. I get it, right? I'm sage enough to understand some stuff, but I'm savage enough to throw down and to gut it out when push comes to shove. And so we have many cases like this. And in many of these cases, corporate America, their insurance carriers, and big law are either lowballing it or just ignoring it and thinking or hoping it will go away. And they're lowballing it, and they're doing this because of the hundreds of plaintiff-side employment lawyers out there who accept the lowball or who are just shooting their shot and not really going to pursue the case. They're just firing off a 1 or 2 page demand or doing an EEOC mediation and saying, yeah, we'll see what we can get. We can get $10,000 here, you know. We'll take it. $20,000, $30,000. Oh my God, fantastic, home run, right? When the case is realistically worth many multiples of that. 300, 400, 500, in some instances, $1 million, $1.5 million, $2 million. I just sent a demand letter in an age discrimination case that I'm about to file. Blatant. The guy was 70, 71 years old, and the new CEO came to him and said, it's time for you to retire. Board wants your retirement, so we already got your replacement. So John, the guy's named John. John's basically like, what do you mean? Like, I wasn't planning to retire. I'm still good at my job, and I had a whole plan. I was gonna work for another 4 or 5 years, and then help onboard my successor and train him up. And I said, well, too late. Sorry, we already got your replacement. So, you're out the door. It is what it is. Guy was making serious money. Well into the 6 figures. And when you look at it from a age discrimination damages framework, the case is just an absolute monster. It's easily worth $2 million. What'd the company do? What'd their lawyers do? Ignored it, right? Sent the demand letter, said, hey, respond. Like, this is a real case. It's ugly. And we want significant money pre-suit, or else we'll just go do it. And they just didn't respond. Fool around, right? That's the fool around phase. Now we get to find out. I can't hide the fact that I am so excited about this. I am so juiced up about this because it is entirely consistent with everything I've done in my life, with who I've been since I was 7 years old. I had my first kind of really rude awakening philosophically, in terms of my perspective, my paradigm, my understanding of the world when I was 7 years old, for a variety of reasons. So there was this kid named Trapper. That was his name, Trapper. Can't make this shit up. I grew up in rural Pennsylvania. This kid's name was Trapper. And, small town in Pennsylvania, not very many black or brown folks around, and I was mixed, and I had an afro, and I was in 2nd grade, and this little shrimpy kid, who I could have beaten up with my pinky finger, called me a nigger. And that was the first time I'd ever heard the word, I didn't know what it meant. I just knew that the way he said it, that it was not nice. I knew it was not nice. I knew it was a really mean, bad thing. And I went home and I told my parents about it, you know? And so that was the kind of first reckoning I had with that. And at the same time, I had a second grade teacher who was a tyrant. She was a screamer. She was right about everything. She would tolerate no dissent. She would actually make second grade kids come up and stand behind her desk and massage her shoulders. Can you imagine that shit? Right? She would literally make kids, she would make 2 kids volunteer to come up and give her like shoulder rubs while she graded papers. She also made you stand up and lead the class in singing God Bless America. For real, right? Facts. I never wanted to be her shoulder massager, you know? She hated me and she was really mean to me. And I did the shoulder massage thing with another kid. It was to be one kid on one side, one kid on the other side. I did that one time and it creeped me out. And I never did it again. And looking back this day at it, it's like, wow, that is so fucked up, you know? Hope they don't do shit like that anymore these days in small town America. But the point being, she would tolerate no dissent. She would tolerate no debate. She was right. She was the authority. Well, that's where a lot of my disdain for authority originated. That and my father, right? So that's the genesis of where it comes from, because it's all personal at the end of the day. That's what so many people don't get, okay? Like this folksy collegial bullshit, okay? I'm sorry. I abide the rules. I treat everybody with respect. I am polite to a fault in my dealings and interactions with other professionals in law. But at the end of the day, it really is personal to me, okay? Companies are, in many instances, engaging in racism, discrimination, age discrimination. They're covering up sexual assaults. They're retaliating against people who raise legitimate concerns or grievances about discrimination. These things are real, and they are ruining people's lives. So I'm going to go out and I'm going to file the first 100 of these cases. I've basically got all of them sitting right there. We get 400 plus leads, inquiries, calls, messages, etc. about new possible cases every week. We reject at least 90% of those. And then I vet the remaining 5 to 10%. We take the ones we think are absolute winners. And so I'm building up the first bucket of 100 absolute monsters. And I'm filing all of them. Unless corporate America, their insurance carriers, their big law lawyers get wise and pay real money to resolve those cases up front. I'm not interested in the lowball. I'm not interested in the 25, 30 grand on a case that I reasonably believe, based on my experience, my expertise, my knowledge, a case that I reasonably believe is worth 300, 400, 500,000, a million. I'm not interested in settling those at $20 or $30,000. Now, of course, that's the client's choice. If a client tells me that they have no problem accepting $20,000 or $30,000 and just putting it behind them and moving on, that's their right. And I will absolutely support them in making the decision that they feel is best for them. But in the vast majority of these cases, the facts are so egregious, and what these folks endured, and often working folks, people who are making 13, 15, 17, $18 an hour, what these folks endured, being treated like less than human, sometimes for a year, sometimes for 2 or 3 or 4 years, with what they endured, coupled with the strength of the case from a legal standpoint, I do not believe that many of these folks will tap out and accept a lowball offer. Because that's another part of case selection. It's not just case selection, it's also client selection. And so at a certain point, when you've been to the rodeo before and you kind of learn what you're doing, if you get enough volume of cases, you can pick and choose, and you're not just picking and choosing strong fact patterns, you're also picking and choosing strong clients. You're picking and choosing clients who came to you, they want you and your firm specifically, they believe in your mission, your philosophy, and they will trust your advice and judgment. That's what you're picking. You're not just picking the good fact patterns, you're picking the strong clients. And so that's what we're doing. That's what I'm doing. I spend virtually all of my time evaluating fact patterns on potential cases and also evaluating possible clients from a client standpoint. And I'm filing the first bucket of 100 of these. And then I plan to file another 100 and another 100 and another 100. At a certain point, I will calibrate what is the ceiling on the number of these cases we can comfortably file and litigate. But suffice to say, we're going to file hundreds of them. And we'll hire more staff, we'll hire more lawyers. But when you compare these cases to defending a $10 million bet the farm non-compete case with 200,000 documents at issue and injunctions, emergency hearings, contempt motions, interlocutory appeals, unique jury instructions, complicated and novel issues of law. And these plaintiff-side employment cases are a cakewalk by comparison. And so we would have 30 or 40 just complicated non-compete cases of all sort of, up and down the spectrum, from poor people to executives, from fighting so an $11 an hour factory worker wouldn't lose their home to, fighting for somebody, some entrepreneur or executive who's got $20 million, at risk. But many of those cases, regardless of the dollars at issue, required a tremendous amount of work. And these plaintiff-side employment discrimination cases are not nearly, not even remotely as taxing. And so that's what we're doing. I'm filing 100 of these. I already started rolling them out. There's more coming this week. Stay tuned.